are made for things to function in a proper manner. One of the basic issues which we've been trying to raise through this platform and through all other platforms which we created is, was the due process of law followed? There is an investigation which happens. Now, if there is incompetence on the part of the investigative agency, who pays the price for it? What is the safeguard of a common man against the incompetency of an investigative agency? This is a question I think which we need to answer.
Yes.
I would like Sushil Bajaj to come and speak.
Ladies and gentlemen, unlike the previous two speakers, I am a man of no eminence. But I have been a practicing lawyer for 31 years. The law has been my life, it has been my religion, and I stand here and say before you today that the Aarushi case raises very serious questions about the administration of justice in this country. Mr. Singh said, democracy means the rule of law, and the rule of law means letting the courts determine. And we do. We trust in the courts. And the question before us today is, have we been served well by those courts over the last few years?
No.
This case, the Aarushi case, started with speculation, started with unfounded rumors, and those rumors became the narrative of this case. There was prejudice everywhere, and that prejudice continued from the beginning right till the very day that the convictions were recorded in this case. And the tragedy is this, and Justice Dhingra alluded to this, the tragedy is this, that everything that the Talwars did was evidence in the public eye of their guilt. The fact that they had good lawyers was evidence of their guilt. It's a separate matter that most of those lawyers charged the Talwars nothing.
Correct.
They appeared for free. The fact that those lawyers advised the Talwars to approach the courts for a redressal of their grievances was further evidence of their guilt. And the question before us is this: when the public was being fed these rumors, these canards, by an irresponsible media, the public was entitled to make a view of their own. It was their prerogative to have a view. To an extent, perhaps it was the prerogative of the police to behave in the way they behaved. But was it the prerogative of the court not to set all of these issues aside and rely only on the evidence, ask the question, where is the evidence? Why were X, Y, or Z not investigated? And when I look at the judgment, I see not a judgment in law. I see a judge declaring a legacy document. He was retiring the next day. He prepared a document that he hoped would be published and that would let him be remembered by generations to come. I mean, it is churlish almost to take stylistic objections to a judgment. But what is the object of writing a judgment that the average person can't even begin to understand? I think my English is fairly adequate. And I read this judgment. When I read it, I had to pick up the dictionary 20 times. I take the liberty of reading just the very first paragraph of this judgment. The cynosure of judicial determination is the fluctuating fortunes of the dentist couple, Dr. Rajesh Talwar and Dr. Nupur Talwar, who have been arraigned for committing and secreting as also deracinating the evidence of commission of the murder of their own adolescent daughter, a butte damsel and sole heiress, Miss Aarushi, and hapless domestic aid Hemraj, who had migrated to India from neighboring Nepal to eke out living and attended routinely to the chores of domestic drudgery at the house of their masters. And this judgment is replete with this manner of observation.
Correct.
It is not a judgment of law. Of course, I believe in the system, so I believe that this injustice will be undone by the appellate courts. But it should never have come to this pass. And the question before us today, the topic actually that was sent to me was Indian judiciary, reality check and need for reform. And I agreed to be here today, one, because I believe a grave injustice had been done, but also because I was told that there would be an opportunity to hear Justice Dhingra, an eminent judge, and perhaps get his perspective on the lawyer's perspective, that over the past few years, for better or for worse, judges have taken the position that they will substitute for poor investigations and inadequate evidence by righting the wrongs of society and convicting people whether there is evidence or not. And I see this every day. Ours is an adversarial system. In an adversarial system, the prosecution puts up its case, the defense challenges that case, and the judges determine based on the evidence. That's the system we adopted. It may not be the best in the world, but that's the system we have. And did the trial judge in this case do that? The evidence, the judgment certainly indicates that much was left wanting. We spoke about the narrative of this case. We spoke about the timelines. And I take the liberty of reminding ourselves that the CBI took over this investigation. The first team of the CBI took over the investigation of this case on the 1st of June 2008 and was replaced by a second team of the CBI in September of 2009. So that's a period of some 15-16 months where they came up with a completely alternative narrative. And in the determination of this case, those 15 months when the first team of the CBI was investigating this case, the evidence suggests a big black hole. It's as if no team of the CBI, no investigation was taking place in those 15 months. I have to ask myself the question, given how this case proceeded, how could there not have been reasonable doubt? How did the judge come to the conclusions that he came? And the answer to that is, the evidence that supported the case of the Talwars was treated as conjecture and surmise, and the conjectures and surmises on behalf of the prosecution were treated as gospel truths.
Yes.
That is within the prerogative of the judge. But the question before us is, should it be? And I think lectures, no lectures, doesn't matter. We need to deal with this issue of a changing judicial mindset. I don't blame judges for that mindset. There is a perception that there are too many scoundrels in society, that laws are made for those scoundrels, and so that lawyers can enrich themselves. And I think that is a perspective that is perhaps without foundation. I don't think that was what was in the mind of the founding fathers. I don't think that was what was in the mind of the legislature when they enacted the various laws. The system has served us well. Judges should now judges should educate the public and say the laws are there for a purpose. Proof beyond reasonable doubt is a measure that is there for a purpose. It's for you and for me, rather than feeding into a vein of despondency that sometimes is felt by the public at large. So yes, certainly, is there a need for reform? I don't know whether there's a need for reform, but is this a time for a reality check? I think the Aarushi murder case more than any other case in recent years, but there are others, would answer that question in the affirmative.